One of the most common and painful family fights that I see after a loved one dies is a fight over that person's bank account. And I'm not talking about huge sums of money. I'm talking about $5,000, $10,000 that family members are hiring lawyers to fight over those bank accounts or to access the money in those bank accounts. So I'm going to highlight 3 issues that tend to come up when someone dies and there's a bank account involved. I want to talk to you about these issues because I want to make sure that you don't make these mistakes that I see far too often as a probate lawyer here in the state of Georgia. The first issue that I tend to see comes up when there's a joint bank account involved. So what typically happens, you'll have a parent who they're getting up in years, they're not able to handle their own finances as well, or they just don't want to handle them on their own anymore. And so they think, let me add one of my children as a joint account holder on the bank account so that they can help me to pay my bills and help me to access money when I need it. And that sounds like a great idea until it's not, until that parent dies and now we're wondering, is the surviving joint account holder supposed to get all the money? Or is it supposed to be split between the remaining children as part of that person's estate? When it's not clearly stated in the bank documents, that's unclear. And it's going to require some kind of court action in order to really solve that unless the family can come to an agreement on their own. Because here in Georgia, the default rule is that if someone is a joint account holder, when one of the joint account holders dies, then whoever else is still a joint account holder and is living, that they receive whatever's left in that bank account. Now, the rule is that you're only supposed to get out the percentage or the fraction of the account that you actually put in. So let's say that you have a mom and a son, and the mom put in 100% of the money, but she added her son as a joint account holder so he can help her to pay bills and things like that. When the mom dies, legally, then all of that money should be part of her estate. But most families are not going to really look at it like that, or I won't say most families, but that joint account holder, that surviving joint account holder, usually they're going to be like, no, mama left me on that account because I was the one helping her with everything. She wanted me to have all the money. And the other siblings are like, no, mama wouldn't have done that because that's the main asset that she left to us. She wouldn't have given it all to you. Well, if we don't have mama here to explain what she was wanting to do, we're left with what the state law is. So like I said, the assumption is that the surviving joint account holder gets 100% of the money, unless the person who actually is deceased, if they put in all of the money to the account. But the only way that you're really going to resolve that is to go to court and fight it out. And most people they don't have the money in a bank account, I'll say, is not worth fighting it out in court to figure out who gets what's left. So I've seen cases where you got a $5,000 bank account and people are willing to spend $50,000 just to try to see who's entitled to the money in the account. And that's not what I want my people doing. I don't want my clients doing that. So you want to be clear when you are setting up a bank account, or if you're thinking, I need some help, I need someone to join me on this bank account. If you don't want that family member, that child, that sibling, whoever it is, to receive 100% of the money after you die, then you need to make that clear. I recommend giving that loved one a power of attorney so that they can access your bank accounts when needed, but they have no entitlement to the money legally on their own. That's what I would recommend, is doing that financial power of attorney or having a power of attorney set up with the bank so that they can handle your bank accounts on your behalf without having a legal right to the money in the account after you die. Or if you want to set things up so that someone can have access to your money if needed, you might want to set up a trust. A trust is an option that could work, where you might have this child as your co-trustee on your trust so that they can handle things that you have placed in your trust along with you. But that option may not be as beneficial depending on what your goals are, but it is an option. That way you can name someone as your co-trustee. They have access to your bank accounts just like you do, and when you die, you get to say where that money goes after you die. You get to put that in your trust. I also recommend, if you are in a situation where you want to make sure that your family member or family members receive the money in your bank account, you may want to name them as a pay on death beneficiary with the bank. That's a simple form you fill out with your bank. You get to say that when I die, I want this money to go to this person or these people. If you do a pay on death designation, it's clear you intended for your money to go to that person or those people, and you get to say what fraction of the account each of those individuals get, so that you can say, my child, my son, he helped me with all of my expenses. He took care of me when I was in my old age. I want him to get 50% of the bank account, and I want the remaining 50% to be split between my other 3 children. You can put that in writing with your pay on death designation and solve all of the potential conflicts up front. So that's the first issue. Joint bank accounts, where someone adds a loved one to the bank account for convenience, but they didn't really intend that they get all the money when they die. The second issue that I see is a frozen or a closed bank account after a person dies. Usually, if there's an individual who is the owner of a bank account and the bank learns that they have died, they're going to either freeze that account or they're going to close that account. And the only person who is going to be able to unfreeze that account or unclose that account or open a new account would be the executor of the estate if there was a will, or the administrator if they go through the court process to become appointed as the administrator of the estate. Either way, going to probate court is going to be required. And this is specifically for Georgia, but it's kind of like this in most states, I would say. You're going to have to go to probate court if that account gets frozen or if it's closed, because they're going to hold those funds on behalf or for the benefit of the estate of that deceased person. So in order to access those funds, you're going to have to possibly hire a lawyer. Then you're going to have to go through the legal process to become the representative of that estate. After that's done, it could take several weeks, several months even. Then you can go to the bank and access those funds. By that time, you've had to pay funeral expenses either out of your own personal account or out of some other fund, or you've had to pay all kinds. You might have to pay the mortgage of the deceased person or other bills that they had. Those are things that are going to present a hardship for the family. So you want to, as a person who is still here and is considering estate planning, you would want to make sure that you have some kind of a plan in place. And in just a moment, I'm going to talk to you about what kind of things you might put in place to help your family to have quick access to your funds in the event of your death, so that you can prevent having accounts frozen or closed at that time. So you want to make sure that your loved ones have access to your bank account after you die. There are 2 things that you can consider. One of them is, just like I mentioned in the first situation, setting a pay on death beneficiary or a pay on death, pay on death designation. You can set that up with your bank so that someone has access to that money as soon as you die. So let's say that you have a child, you have 3 children. You name one of those 3 children or all of those 3 children as the pay on death beneficiaries on your bank account. So that means that as soon as you die, if they have a death certificate, they can go to the bank and access that money. Now, there might be a little bit of a time lapse in that situation. So another option would be to create a revocable living trust while you're living, and you can be the trustee as long as you're alive and healthy and able to handle your own affairs. Then after you die, there will be a successor trustee who immediately takes over after you have died. So they will be able to go to the bank and show the papers that they are the successor trustee. They may have to provide a death certificate or some other proof of death. More than likely, they're going to have to do that. But they'll be able to get access to the funds more quickly. So that's something else you might consider, is setting up either a pay on death designation or a revocable trust that will become irrevocable after you die, that has a successor trustee in place. That's going to prevent your bank accounts from being frozen or closed in a way that your family is not able to access your money. So that's the second issue that I wanted to address. The third issue that I wanted to address is what happens when a will is not enough. So a lot of times people think, well, I don't want my family members to fight over my money after I'm gone. Or they might think, I don't want my money to be frozen when I'm gone. I want my family to be able to access that money quickly. So I'm going to draft a will and I'm going to name somebody as the executor. They'll be able to handle things as soon as I'm gone. The issue with that is that a bank account is only going to be part of your estate, and thereby controlled by your will if you name your estate as a beneficiary of your bank account, or if you don't do anything, if you just have that bank account in your name and then you die, there's no beneficiary or designee stated. So then in that situation, that money would become part of your estate. But let's say that you had a joint account like we talked about before. That will is not going to get around that joint account. So let's say that you have a will that says everything in my bank accounts is going to be split 3 ways between my children. But then you have a pay on death. Well, let me not say it's not a pay on death designation. If you had a joint bank account with one of your children for that convenience purpose, and you had that will that said, I want my bank account split between my 3 children, more than likely that joint bank account designation is going to control over your will. So your will might say one thing, but if that bank account says something different, that's what's going to be in control. So there's situations where a will is not necessarily going to be enough. Another thing is what we mentioned before, is that you have to go through the probate court. That could take some time because you might need to retain a lawyer, have them draft up the paperwork. Then they have to file it with the probate court, provide notice to all the heirs. If there are any heirs who contest or any heirs who might have an issue with or don't respond to the process, that could take additional time to get them properly served and notified. There could be a court hearing if there is an objection to the will. Those things take time. So you want to consider an option that is more immediate, such as I mentioned before, that pay on death designation, or having a revocable trust where you name someone as the trustee of your trust, who then has control over your bank account. So the main thing I wanted to highlight were those 3 issues. 1, a joint bank account. 2, the possibility of an account being frozen or closed at the time of a person's death. And 3, the situation where you might have a will that says one thing, but that account, the way it's set up, is going to control how things operate. So there's some things that I would want you to do to prevent this kind of situation, protect your family members from being in this kind of a situation. Number 1, let's make a list of all your bank accounts. Once you do that, I want you to decide who is going to receive each bank account after your death. Then go ahead and set up some pay on death designations, or if you're going to set up a trust, then you can specify in that trust document how you want those different accounts to be diverted. But I want you to take those steps so that things don't happen by default. They happen by design, by intentionality. I don't recommend that you add joint account holders unless you definitely want them to get 100% of your bank account after you die. If you want to have someone to be able to access your money for you while you're living, consider a power of attorney. They can help you with that. And your bank might have a special form that you can fill out to designate someone as your power of attorney for that account, or you can work with an estate planning attorney to set up a financial power of attorney. That leads me to the last point. Work with an estate planning attorney to help you get your estate plan in place, to make sure these things are covered. You want to set up a will, set up a trust, set up your bank accounts, make sure everything is synced and working together. And your estate planning attorney can help you to figure out, do we need to do a will? Do we need to do a trust? Do we need to do a combination of the two? Or perhaps we want to set something else up altogether. So these are the things that we work with our clients on so that they have a comprehensive and complete estate plan. And if we can help you with your estate planning to get you set up and prevent family fights from happening on your dime and in your name, then give us a call or schedule a legacy planning session using the link that we have provided below. We would love to help you. Also, make sure that you like this video, subscribe to our YouTube channel, and share this information with a friend if you think it'll be helpful. Thank you so much. This is Attorney Veronica McClendon, and I will see y'all next time.